Between 1975 and 1983, psychologist J. E. Rankin served as a consultant on at least 14 criminal prosecutions in which the defendant's confession was later found to have incorporated details supplied by investigators before the statement was signed. He was not considered unusual in his field at the time. The architecture of the modern American interrogation room traces its foundations to a single man working out of Chicago in the 1950s. John E. Reid was a polygraph examiner and former police officer who believed, with genuine conviction, that a trained investigator could read guilt from the body, from the angle of the shoulders, the stillness of the hands, the particular way a person avoided or sustained eye contact. What he built from that belief was a 9-step interrogation method, published in 1962 in a manual he co-authored with Fred Inbau that would go on to become the dominant framework for criminal interrogation across the United States. Departments adopted it, prosecutors relied on it, courts accepted its fruits without significant scrutiny. For decades, the Reid technique was less a methodology than an assumption, a shared professional faith that a confession, properly obtained, was the clearest possible evidence of what had actually occurred. What the technique required of its practitioners was a fundamental reorientation of purpose. The investigator who enters an interrogation room under Reid's model is not there to determine whether a suspect is guilty. That determination has already been made. The investigator is there to obtain confirmation of a guilt that is presumed. The 9 steps, including what Reid called positive confrontation, the withholding of sympathy, the introduction of minimization themes designed to make confession feel like the rational choice, are not tools of inquiry. They are tools of extraction. The distinction is not academic. It is the difference between a question and a conclusion wearing a question's clothing. The research began accumulating quietly, in the way research does, through journals that prosecutors did not read and academic conferences that investigators did not attend. Saul Kassin, a psychologist at Williams College, published peer-reviewed findings in 2012 that produced a result which should have been impossible within the logic of the Reid system. Innocent suspects, his data showed, were statistically more likely to waive their Miranda rights than guilty ones, not slightly more likely. Measurably, consistently more likely. The explanation Kassin offered was precise. Innocent people believe their innocence will be self-evident. They walk into the room expecting to be recognized. They cooperate because cooperation, to them, is proof. They do not understand that the room is not designed to discover what happened. It is designed to confirm what the investigator has already decided. Richard Leo, a criminologist at the University of San Francisco, added a temporal dimension to this picture in 2009. His study identified that interrogations exceeding 6 hours in length correlated strongly with a measurable increase in false confessions among subjects with no prior psychiatric history, people who, by every clinical measure, were functioning adults without vulnerabilities that might explain a capitulation to pressure. 6 hours in a room with no natural light, with investigators trained to introduce uncertainty, to suggest that memory itself might be unreliable, to offer the implicit promise that confession leads to exit, produces results in ordinary people that have no relationship to what those people actually did. The body reaches a threshold. The mind negotiates with it. And the statement that emerges from that negotiation can sound, on the page, indistinguishable from truth. On April 19, 1989, in New York City, a woman was found near death in the northern section of Central Park. She had been beaten so severely that her body temperature had dropped to 80 degrees. She survived with no memory of the attack. Within days, 5 teenagers, aged 14 to 16, had given videotaped confessions to the assault. The confessions were detailed. They were specific. They were internally coherent in ways that seemed to exceed what invention could produce under pressure. Prosecutors and investigators described them as voluntary. The 5 teenagers described something different: hours of interrogation, no parents present for significant portions of the process, investigators who already knew what had happened and needed the boys to confirm it. The jury heard the confessions. The jury convicted. They served between 6 and 13 years. In 2002, a man named Macias Reyes, already imprisoned for rape and murder, confessed to the assault. His DNA matched evidence recovered from the scene. None of the 5 teenagers' DNA matched anything. A court vacated all 5 convictions. The confessions, detailed, specific, videotaped, apparently coherent, had described an event that, in its particulars, the 5 boys had not witnessed because they had not been there. The Innocence Project, founded in 1992, has now documented that approximately 29% of DNA exoneration cases involved a false confession or incriminating statement as contributing evidence, not coerced confessions from individuals with obvious psychiatric fragility, not statements retracted immediately and thrown out before trial, confessions that were admitted, confessions that juries believed. Confessions that ended in convictions that stood for years, in some cases decades, before the biological record made the official account impossible to sustain. Which returns us to J.E. Rankin, consulting on 14 prosecutions between 1975 and 1983, in which the confessions were later found to contain details that had traveled from the investigators to the defendants before the statements were signed. His presence in those rooms was considered professional. His methods were considered sound. The confessions he helped produce were considered evidence. 14 cases is a number. Behind each number is a specific room, a specific transcript, a specific person who signed their name to a version of events, assembled partly from what they were told, partly from exhaustion, and partly from the reasonable human assumption that cooperation would eventually resolve the situation in their favor. What we do not know, what the record, even now, does not tell us, is how many more rooms there were that produced the same result, and whose names we simply have not found yet.